So good afternoon, good evening, everyone, and a very warm welcome to the final session of this year's International Summer School on Mediation. On behalf of Nivaran, I'm delighted to greet our distinguished guest faculty, Mr. Tirado, and all our participants who have joined us from around the world. I am Devavrat. I'm an advocate practicing before the Supreme Court of India and a mediator based in Delhi, and I have the pleasure of being your host for today's session. Nivaran presents the summer school in collaboration with the Commonwealth Lawyers Association and the Singapore International Mediation Center. Over the last 11 days, we have explored a rich variety of themes in mediation, hearing from leading voices in the field. Today, we have the privilege of learning from Mr. Joe Tirado, an independent international arbitrator based in London with more than 35 years of experience in dispute resolution. He has held senior leadership positions in top firms in UK, US, and Spain. He is a solicitor advocate with full rights of audience before all civil courts in England and Wales, a CEDR accredited commercial and investor in state mediator, a civil mediation council fellow, and a former ICD SID conciliator appointed by the president of the World Bank Group. Mr. Tirado has handled cases in over 70 jurisdictions with a total value in dispute exceeding $10 billion. That's a huge figure. He has advised on more than 100 international arbitrations under all major institutional and ad hoc rules and conducted over 50 mediations globally. His contributions to his profession include serving as past co-chair of the IBA Mediation Committee, as well as membership in leading arbitration and mediations panels in European Unions and United Nations. Coming to today's presentation, Mr. Tirado will focus on the Singapore Convention on Mediation, why and how it came about, an overview of its key provisions and where to grow from here. So the presentation will last around 30 minutes, followed by 20 minutes question and answer session. Please post your questions in the chat box during the talk. With that, it is my pleasure to give the floor to Mr. Joe Tirado. Mr. Tirado.
Thank you very much, Devrat. Thank you for that kind introduction. Hello to everybody, wherever you are in the world. I know most of you probably are in India, so thank you for sharing your Sunday, evening almost now, with me for the next hour. I hope to inform and provoke some interest and some discussion with my presentation today. But let me also, first of all, just thank, of course, the organizers, and in particular, to Sri Sanatharan Krishnan for the kind invitation to join you today. And if I may also, just to take a moment to commend Nivaran, the Commonwealth Lawyers Association and Singapore International Mediation Center for organizing such an interesting program for this 6th virtual summer school of mediation. I did look through the program, haven't seen them all, but they all look tremendous. And so many congratulations, and I understand the feedback and attendance has been phenomenal, so well done for that. So in the next 30 minutes, we haven't got a long time, and much of this may well be information you already know, but I'm going to be giving an overview on what's formerly known as the United Nations Convention on International Settlement Agreements Resulting from Mediation, otherwise known as the Singapore Convention on Mediation, or more simply the Singapore Convention, or for today's purposes, just simply the Convention. It's extremely timely in that we've just celebrated the 6th anniversary of the Convention. The 7th of August was the birthday, for want of a better term, for the Convention. And indeed, I'm sure many of you who are listening may well be attending either in person or online the Singapore Convention, the next iteration of which is due to take place in Singapore on the 25th of August 2025. So this is a particular time of the year, I think, when there's lots of interest in the Singapore Convention generally, and worthwhile just reminding ourselves about it. It still exists, and obviously I think the challenge with any of these major initiatives is to keep them alive and in the forefront of people's minds. So this is a great opportunity to do that. And again, I thank you for inviting me to speak on it. Of course, I think while chronologically the topic of enforcement always comes at the end of a dispute, the reality is in practice, it's one of the first issues that needs to be considered, no matter how well designed a dispute resolution process is. And it's important to have confidence in the outcome of that process, whether it's determined by an adjudicative process such as litigation or arbitration, or a negotiated process such as mediation. I think it's true to say that while mediation has been around for centuries, if not millennia, its adoption and acceptance in most countries has been, quite frankly, very slow and patchy. That does not mean that there has been considerable development and progress during the last 20 to 30 years, particularly in jurisdictions such as my home one, which is the UK. We've seen enormous, since we really started to begin to take mediation seriously and embrace it. This is in the late 80s, early 90s, and then certainly embrace it more in the last 20 years or so. So we've seen a considerable progress. We've had other jurisdictions in Italy where you've gone from a jurisdiction where their legal profession were going on strike at the concept in reaction to the proposal to have mandated mediation from those days, to where Italy is arguably one of the most, if not the most, forward-thinking in terms of mediation on, certainly at least on continental Europe. I think that shows an immense progress, but it's global. I mean, Ecuador is one of the leading jurisdictions and has a very commendable and healthy mediation culture. And of course, of relevance for the majority of the audience today, I'm sure India is seeing huge interest, and I was there, fortunate enough to be there recently. I was very inspired by the discussion, the enthusiasm for the possibility of mediation, and the challenge is always, one thing is talking about it, but converting that into concerted action going forward. So it's great that we are talking about it, but I think nonetheless, for many reasons that we can debate, and perhaps I hope we may have some time to discuss them in the question and answer, mediation has been, to put no finer point in it, a hard sell, I would say, both domestically and certainly internationally. I should have just said at the caveat, obviously these are my views. I don't mean to offend anybody, but I mean, and I'm happy to debate if people want to take issue with those views. But it certainly is the world commerce and international trade continues to grow and become ever more interconnected, notwithstanding the current upheavals we're seeing in the world. There is definitely, I think we can all agree, an increasing need for efficient dispute resolution mechanisms to manage what are sadly inevitable disputes that will arise. And I think it's fair to say that the considerable costs and delay involved in both litigation and arbitration, and not only that, the growing risks associated with being able to enforce judgments and awards has led to greater frustration in the existing system and a growing focus on what has been termed, quote, alternative, close quotes, methods of dispute resolution, most notably mediation. I labored the point a little bit because I think actually what has happened, the reality of it is, again, this is a personal view, I think mediation is arguably one of the more natural forms of dispute resolution, and it's actually litigation and arbitration that's rather hijacked the dispute resolution process, and they should really be the alternatives. But again, that's maybe something we can explore further in the Q&A question. But, and as a result, I think, of that, and COVID had its part as well. I think one of the very, very few good things that ever came out of COVID was perhaps a refocusing on doing things differently. And certainly that applied to dispute resolution and mediation. I think I've seen a bit of a renaissance, both again in my home jurisdiction and all around the world. So I think there's been a lot of effort to try and promote mediation and remove obstacles, some of which may be perceived obstacles or actually real ones, in order to try and broaden its use and acceptance. And certainly one such area identified of concern was the international use of mediation, and a view that perhaps mediation was often limited by the difficulty of enforcing settlement agreements across different countries. Whether this was a perceived or real concern, I think is somewhat moot. I have my own views on that. I, again, won't preempt the question and answer session. But the important point is that I think the removal of this concern is one less barrier to consider mediation. So anything I think that promotes mediation has got to be viewed in that lens of it's got to be a positive thing, and to make mediation more attractive to businesses and individuals engaged in cross-border transaction. Well, I think work really began earnestly in this area about 12 or 13 years ago. And indeed, I don't want to inflate my role in this, but I do have a connection with what was the beginning, if you like, of the work and the debate and consideration for the Singapore Convention. And indeed, it was during my tenure as co-chair of the IBA Mediation Committee that we established a working group to explore this very idea. It wasn't my idea, I stress that, but a group of us got together, and I think while we thought this is, well, an interesting idea, do we really need it? We got it together, but it did seem to come together at a time where a number of other important organizations were considering this. And so I'm always very proud of the fact that those within the IBA were also members of other organizations that went on to promote the idea to what was then became the Singapore Convention. It was also at that particular time we were in discussions with the US State Department, no less, who was taking a great interest in the subject. However, of course, there were no existing frameworks like the New York Convention for Arbitration, since that, of course, doesn't cover mediated settlement agreements. And so in response to that, the United Nations Commission on International Trade Law, UNCITRAL, began working on a treaty to bridge that gap. And just bear with me just to talk through the brief history of this. At its 41st session in July 2014, the UNCITRAL Commission agreed that the Working Group 2, this is the one on dispute settlement, this is Working Group WG2, should consider the issue of enforcement of international settlement agreements resulting from conciliation, they say, I think read mediation proceedings, and report to the Commission at its 48th session in 2015 on the feasibility and possible form of work in that area. So that's really where the title is the genesis. This is where we are starting to see things, some real traction and the wheels beginning to move. In July 2015, the Commission took note of the consideration of the topic by the Working Group 2 and agreed that Working Group 2 should commence work to identify relevant issues and develop possible solutions, including the preparation of a convention, model provisions, or guidance text. The Commission also agreed that the mandate of Working Group 2 with respect to the topic should be broad to take into account the various approaches and concerns. 85 member states, 85, and 35 non-governmental organizations participated in the deliberations which then took place during the next 6 sessions. So, as I say, not that long ago, when you consider the convention was adopted in 2019, a lot of work happened in a very short period of time by a lot of people. So I think it's a great reflection on what can be done when people are really focused. And so through those deliberations, Working Group 2 reached a compromise on various issues. It was contentious. There was a lot of different opinions in this. I didn't attend the various sessions, unfortunately, but those that did attend were, I think, surprised by some of the heated exchanges that were exchanged. But that is obviously the nature of debate. That's obviously the product of compromise as well. But the Commission expressed support for Working Group 2 to finalize its work by preparing a draft convention on international settlement agreements resulting from mediation, as well as a draft amendment to the UNCITRAL Model Law on International Commercial Conciliation. That's the Model Law of 2002. So the convention was finalized at the 51st session. If you remember, it started at the 47th. So the 51st session the UNCITRAL Commission session, which came to a close in July 2018. The amended model law, that's the UNCITRAL model law on international commercial mediation and international settlement agreements resulting from mediation 2018, was adopted at that session, 2018. In December 2018, the United Nations General Assembly, by consensus, passed a resolution to adopt the United Nations Convention on International Settlement Agreement resulting from mediation, recommended that the convention be known as the Singapore Convention on Mediation, and authorized the signing ceremony of the convention to be held in Singapore on the 7th of August 2019. As I say, we've just had the 6th anniversary. I think it's true to say, it's very easy to kind of overplay these things, but it's truly a landmark. The Singapore Convention is truly a landmark multilateral treaty designed to offer a uniform and efficient framework for the enforcement and invocation of international settlement agreements resulting from mediation. We have to remember that prior to the Singapore Convention, enforcing mediated agreements across borders could prove difficult, leading to delays and increased costs and uncertainty. There was no uniform framework. Parties had to relitigate or start enforcement proceedings locally, which limited mediation's appeal. Of course, the convention also helped solve this problem by providing a clear, predictable process for recognizing and enforcing mediated settlement agreements across signatory countries. So that's the history. And we're basically, so let me just look, I think it's worthwhile looking, well, why do we need it? What was the intention of it? I thought the preamble of it, again, rereading it from my own benefit in preparation today, I thought was helpful. It's short, but it shows what was behind the signatories to the convention. It says, recognizing the value of international trade of mediation as a method of settling commercial disputes in which the parties in dispute request a third party or persons to assist them in their attempt to settle the dispute amicably. So right up there, it's a publicity. I'm not going to use the word stunt. I think that would be derogatory. It's not, but it was there to promote mediation, and it's a method to do that. And as I said, I think anything that does that has to be good. In the overall, when you look at the overall tools that are available in dispute resolution, so I think it's right out there. First point it says noting that mediation is increasingly used in international and domestic commercial practice and as an alternative to litigation. It says one could even add arbitration. And it says, then goes on to say 2 more points, considering that the use of mediation results in significant benefits, such as reducing the instances where a dispute leads to the termination of a commercial relationship, facilitating the administration of international transactions by commercial parties, and producing savings in the administration of justice by states. Again, clear promotional statement to the benefits of mediation. And then finally say in the preamble, convinced that the establishment of a framework for international settlement agreements resulting from mediation that is acceptable to states with different legal, social, and economic systems would contribute to the development of harmonious international economic relations. So all of this is actually driven, there's a justice element, but there's also a pragmatic commercial incentive to all of this to promote international economic commerce and relations. So that's really, I hope, given it's a bit of a whirlwind overview of the background, the origins, the genesis of the convention, and why it was developed. I think it's quite helpful. It's very short. I invite you to revisit it, but I thought I'd just flag a couple of the key provisions to remind ourselves what's in it. Number 1, of course, is the scope. And it covers, applies to mediated international. So that's important to stress that it has to have an international element. This in the settlement agreements resulting from facilitated negotiations after disputes arise. The mediation settlement agreement must be commercial. That's the other kind of key word in terms of the scope. This excludes, therefore, disputes arising from transactions by consumers for personal, family, or household purposes, or relating to family, inheritance, or employment law. So very clear, international, commercial. And what it's also, it stands alone. The convention does not apply to settlement agreements that are enforceable as a result of a judgment or an arbitral award. It's a standalone process. In terms of recognition, it says, and enforcement, countries undertaking the convention agree to recognize and enforce these agreements if requested. That's the mediated settlement agreements, of course, provided certain formalities are met. And an example of that may be that the agreement must be in writing and the parties should have achieved it through a formal process. Courts can review if need be, but only check if the agreement is valid. And the court's role is not to reassess the substance of any settlement. And settlement agreements can be directly enforced as a result by the competent authority of a party state in accordance with its rules of procedure and under the conditions laid down in the convention. Important to flag out, to highlight some of the exceptions to the rules. Article 5 of the convention, the competent authority of a party state to the convention may refuse to grant relief on grounds laid out in the convention. Very few, most of these all relate to due process. You won't be surprised. First one is if a party to a settlement agreement was under some form of incapacity. Next, if the settlement agreement is not binding, null and void, inoperative, or incapable of being performed under the law to which it is subjected or has been subsequently modified. And next, it's important, this is the role of the mediator. If there was a serious breach by the mediator in terms of applicable mediator standards, or failure to disclose circumstances that raise doubts as to the mediator impartiality or independence, without which the party would not have entered into the agreement. I just pause a second and put a little bit of emphasis on this ever-growing, I think, importance of this question of disclosure and impartiality and independence. And then the kicker, if you like, the catch-all, which is arguably the area, and we'll touch on this in a moment in greater detail, but of course, if the relief would be contrary to public policy of the state, of the party state, which is, there's the alarm bell. That depends how you determine public policy. And we know from our experience with the New York Convention that there are states who apply public policy in different ways to others and have caused problems as a result in certain jurisdictions. So that's one to watch. Still early days, I think, on that, but there is that general catch-all. And then I think finally it's worth pointing out that parties have been given the option to make following reservations in relation to the convention. And that's, first of all, to qualify that the convention would not be applicable to settlement agreements to which its government or other public entities are a party. And secondly, and this is an important one, to adopt an opt-in approach rather than an opt-out. So the default position is opt-out, i.e. the convention, if you sign it, ratify it, is an opt-out unless you have this reservation to opt-in, which provides that the convention can only apply to the extent that the disputing parties agree to its application. So that's one to watch as well. A couple of, finally, I just end on the procedural aspects. The convention sets out the process for parties to request enforcement, including the need for supporting documentation and compliance with formalities. And I think I would just end the summary by saying it provides a pretty balanced framework that strengthens the enforceability of mediated settlement agreements. So there are the, again, brief overview of the key terms. Where are we with the convention? I think it's worth pointing out that 46 countries, including the two largest economies, still, the United States and China, as well as 3 of the 4 largest economies in Asia, China, India, of course, and South Korea, have signed the convention on the day it opened for signature. Another 24 countries attended the signing ceremony in Singapore to show their support for the convention. On the 25th of February 2020, you won't be surprised to hear this, Singapore and Fiji became the first 2 countries to deposit their respective instruments of ratification at the UN headquarters in New York. And this was before even the convention itself came into force, which was the 12th of September 2020. So Singapore and Fiji were the first off. Qatar was the other one just before September. But as of yesterday, 58 countries have signed the convention, and 18 parties have ratified it, with Costa Rica being the latest to ratify in March 2025. When you go through the list of signatories, it truly has global reach. It's a mixture, it's from all around the world, a mixture of developed and developing nations. So it's truly an international instrument. And I think in terms of perhaps looking at future evolution and conclusion, I think some may say, well, 58 isn't that big a number, is it? Well, I remind you, that's 30% of UN member states, which is pretty good going, I would say, in 6 years, compared to the 66 years of the New York Convention, which has obviously been going up a lot longer, has been extremely successful. So I would just caution and say it's early days. And I think one needs to just pan back, also extremely impressive, given the way the world and other competing interests for all governments all around the world, COVID obviously being the most obvious one, distracting governments from doing other important work. So I think that's a significant number. Not only my hope, my expectation is that number will continue to increase as time goes by. Of course, what we want to see are those, first and foremost, those leading the way are the ones who have signed it. I think they really do need to step up. US, China, India, my friends in India, and of course the UK. I'm not ducking that. I keep hearing periodic talk about it, but as I say, I think one has to be realistic in terms of competing priorities at the moment. But I think the sooner they sign up, the harder it makes it for those who haven't signed up not to sign, and of course encourages other countries and blocs to sign up. The obvious missing party in the treaty, and it's caused some controversy, is the EU, which for this purpose would sign up as a bloc of 27 countries. They are very pro mediation, so it's a little bit of a surprise. But again, I'm prepared to give them the benefit of the doubt. It's because of competing issues, and of course we have in this part of the world as well, although it affects us all, the Ukraine conflict going on. So I think once you see those countries signing up as well, we will start seeing a snowball effect, and it will not take as long as it did for the New York Convention to have as many members. Indeed, I think one would then look at them as sitting within the same kind of framework as part of the overall dispute resolution tool that are available to us all. And I think so generally, I think it will be, we will see greater acceptance and growth in mediation. And I think the fact that it's being led by states is very helpful, because there's an interesting debate we can have as well. I mean, one aspect, it doesn't really differentiate between commercial and investor state mediation, but there's a whole growing push and desire to look at using mediation as a realistic tool for resolving investor state disputes as well as commercial arbitration. So again, I think all of this is very positive. I think in terms of challenges, one doesn't want to duck these issues. I mean, I think ensuring uniform adoption and implementation will be very important. It's still early days. We don't know how that's going to pan out. But I think if you start seeing states clearly being partisan over using or exploiting the public policy exemption, for example, they will be called out. People will know who they are, as they have done with the New York Convention in the past. But all I would say is, I mean, I'm hoping that we start with a positive view. You won't see that. But I think that needs to be monitored, as indeed the use of the reservation and exemptions that I referred to before, to see how that is adopted, and whether anybody, I'm not aware of anybody having expressed the opt-in provision yet. And as I say, the default position is opt-out for the convention. And so with that, and I think I'm just about within time as well, my concluding thoughts is the Singapore Convention is, I think, a truly transformative step in global dispute resolution. It encourages the use of mediation, as I say, as a whole, both commercial and investor state. And again, it's to promote using less reliance on court litigation or arbitration. I always say at this point, it's important to look at mediation as a tool, as one of the tools in the dispute resolution. It may be that it runs in parallel with either litigation or arbitration, but it's an important tool rather than looking at it when everything else has failed, which I think traditionally seems to have been the default position. That is changing, I'm pleased to say. I think the convention's global reach is expected to expand further, as I was saying before, as more countries see the benefits of facilitating cross-border mediation enforcement. And with that, that kind of concludes my overview of the Singapore Convention. Forgive me if for those, I'm conscious will already know a lot of this, but sometimes it's helpful just to remind ourselves nonetheless. And I hope I've managed to provoke some thoughts and comments in the Q&A, which is where I hopefully we'll all learn some new stuff. So I think with that, Devat, I'll hand back to you. Thank you very much for taking the time to listen to me.
Thank you very much, Joe. This was a very insightful and comprehensive presentation by you, right from the history, genesis, background, and the context of the practical implications of the Singapore Convention in a way that it is directly useful for the the practitioners and the policymakers alike. Now, before I summarize it, we should move to the question answer segment, and we have some questions. So I'll take the questions which we have got before I put my own questions. So Mr. Dr. Yashpal Sharma, he is asking how the convention encourages the use of mediation, providing businesses for settling cross-border disputes. That is
thank you for the question. I kind of alluded to it at the beginning. I mean, some people, including me, I have to confess, have said, and indeed, when I mentioned when we set up the task force, it almost again, it sounds a little bit derogatory, and I don't mean that, because it's clearly a very helpful addition, I think, to the promotion of mediation. But some people have said that it's a solution in search of a problem, because I've not seen convincing data or evidence, other than the odd comment anecdotally, that there was ever a problem and this was needed. I think those of us who've been involved in mediation for quite a long time, it goes through cycles. It blows hot and cold. There's a real interest, and people become a little and you see progress, and it seems to hit a ceiling, and then there's a little stagnation that happens. And I think this was happening around about the 2010 period, in a sense, well, what more can we do to promote mediation? And somebody came up with the idea of, I think I said in my presentation, whether it's perceived or actual. I would say it's more perceived than actual. I never had an issue with enforcement, and one of the beauties of that a mediated settlement agreement, this is it's a creature of the parties, of course, using the mediator to assist them, as opposed to when you're trying to enforce an award, an arbitration award or a court judgment. This has been imposed on you by a court, and that's a whole new process, and it's very, very contentious and expensive. In my personal experience, where I have not seen, in the few occasions I've not seen a mediation agreement fulfilled, is because parties knew that one of the parties, for example, was in serious financial difficulties. They needed, they perhaps agreed a settlement period of schedule of payments, but ultimately the company collapsed. So there was an element of hoping that wouldn't be the situation, but it didn't, and that didn't transpire. But it wasn't because one party didn't want it to happen. And so I think it's interesting that it's presented in that way. But as I say, in my personal experience, in my humble personal experience, I never saw it as a problem in reality. And as I said, when you look at the preamble, it's more general. It's much more general about the benefits of mediation anyway, rather than that specific. And I think that's what it's trying to do. And our colleagues and friends in Singapore have done a fantastic job of, number one, getting it signed in Singapore, so they've got their name on it, which is, I don't knock them for that at all, but they're great. Every year they have this Singapore Convention Week, which focuses everybody's attention on it globally, not just in Singapore. So it keeps it in everybody's mind. With the fact we're talking about it today, I think it's not a complete coincidence, given that that's coming and it's important. So again, it's more of that general confidence, and it's one less obstacle for somebody who has no idea but will throw something in there and say, oh yes, but how do you enforce all of this? Well, then that's taken away because we now have the convention. Bit of a long-winded answer to the question, but I hope that it gives a little bit more.
No, I think it was quite comprehensive, covered the subject. No, the next question is from 1KS. The full name is not there. So it asks that, can you share what were some of the critical arguments during the convention negotiation?
Well, I think number one, whether it was needed. And I think that, again, it's whether it's opt-in, opt-out. I think part of the problem when you're talking about mediation, and this is part of the issue we're all having at the minute with mandated mediation, it seems to run contrary to the concept of consensus building, to impose something on parties. As I say, sadly, I wasn't there in some of the more contentious ones, which I think would have been more interesting. And I think, look, I'm going to, at the risk of being controversial, but I've kind of given the caveat, it's just me. I think there's a resistance to those who, not everybody's a born mediator, not everybody believes in mediation. I think there's been a resistance for far too long from practitioners, but clients as well, I would say, to truly wanting to understand the benefits of mediation. And I think there's an inherent kind of bias, if you like, against it. And probably there was some, well, to be fair to them, I think they were testing the grounds, and they're perfectly legitimate. But I do wonder whether perhaps they were looking at it from a certain lens that wasn't helpful. And to be fair, to give the other side of the coin, I think there are some people who oversell mediation, and it looks like the panacea, and it's all very evangelical, and it all looks like this is going to save the world. And I think a bit of counterbalances, arguments to counter that is not a bad thing in itself. And actually, what you end up is with sensible compromise, which is what I believe we ended up with the Singapore Convention.
Thanks, Joe. Next question is from Shireen. She asked that how were the cross-border settlements being enforced prior to Singapore Convention, say in US, UK, or China?
Yeah, no, well, as I alluded to, very difficult, because at the end of the day, you have, certainly if it's if I'm using a UK example, which is easier for me to say, what you have, a mediated agreement is a creature of contract. And so it's a private contract between the parties, and you have two options. If your settlement agreement is not in, you can either say enforce the settlement agreement, and then for breach of that contract. But you would have to go to if the assets somewhere else to enforce that contract is in another jurisdiction, you would have to go through the whole process of potentially starting a whole new set of proceedings on that agreement in another jurisdiction. There may be some jurisdictions where you have recognition of your judgment or award, and you could perhaps go on that basis. But it would be effectively starting again. Whereas now, as I say, you have a proceeding here. If you can show you've jumped through all the relevant hoops, the court can enforce it effectively as of right, as an agreement directly. So it just simplifies the whole process, and you're not in the spectre of having to commence a whole proceeding again to litigate, whether that's in the litigation sense or in the arbitration sense, your whole case before another court. Effectively, you've already done that, and all you need to satisfy the court that has signed, of course it has to be a signatory court to the convention, is that you have a validly entered into mediation agreement that is international, is commercial, has been signed, and follows the formalities that have been set out in both the convention or a potential reservation.
Thanks, Joe. There's a very interesting question by a law student. It's not
Oh dear,
particularly
they're always the most difficult.
but I would like to take this question as she asked that. It's a generic question basically, but Mehak Gupta wanted to ask that she wanted to make a career in the mediation field, so in the international disputes. So, what guidance can you give to fresh law graduates like her who wish to pursue this path?
One sec, I just need to make sure my
please,
computer doesn't run.
Yeah.
Well, number one, I commend her. I'm glad she's thinking of that. I think there is a huge world of opportunity out there in this field. Either as a standalone subject, if you like, mediation, certainly I think holistically, a part of any dispute resolution practice, I think is fundamentally important that one is aware of this. And I think if you don't, if you think, well, I would say that, wouldn't I? Or I don't buy that. I do caution you, if you don't do it, your clients will find out who is considering these options and will not be impressed when you either don't know or not presenting them with alternative ways of resolving their disputes. So that's just a friendly warning from me. But I think in terms of, there's a lot of interest, and I think all I would say, it's a tough market. It's a tough thing to get into. The reality of where we currently are, there are way too many mediators for mediation, but this is what we're talking about. The more we promote mediation, the more there will be growing demand for mediators. And of course, mediation is an extremely broad church. I mean, we're talking and focusing, and that is my area, is particularly commercial mediation. But of course, we have the traditional more family employment type of mediations. But I think as we see increasing comfort and demand from clients for mediation, we will see a greater use for mediators. So, I mean, I think it's to obviously to get up to speed in terms of the process. There's nothing like experience at the end of the day. Looking for mentorship, people who are just going to observe mediation, so is certainly very helpful. There's no substitute for experience, but it's also, there's no shortcut. I think these things take time to establish yourself as in terms of training, accreditation. I would encourage you to look at getting accredited. That's always a great starting point in terms of the education. But ultimately, there really is no alternative rather than the actual practical experience. And that's, it's a bit chicken and egg, and that's easier said than done. I know it's frustrating, but there's no silver bullet. It's the bottom line either, to be brutally frank. But I do encourage you to hang in there, because I think there is, things are changing. I think we are in a moment of time where we have a real window of opportunity to move the marker on this, I think, towards using mediation, as I say, not necessarily as the alternative, but I think re-establishing it as where it should be. Is the really litigation arbitration should be when mediation doesn't work out, and it doesn't always succeed, and there are reasons for that. But again, a little bit vague, hard to be super specific, but I think getting involved, I commend her for taking her Sunday out as well, as I think my children would struggle to come jump on a video like this to listen to mediation on a Sunday. I think that shows commitment, and I wish her luck.
Thank you, Joe. I have very short questions from my side. Like for practitioners like us, what are the 3 provisions of the convention you believe are essential to remember, and why, if you can tell us?
Well, I think
3.
Well, number one is to, and this is again, I've said it several times now, but I mean it, and I think it's that we don't forget it's there, because the thing, one of the trouble with a lot of these instruments or initiatives, there's a lot of fanfare, and then people forget about it. As I say, fortunately, our friends in Singapore don't let us forget about it, because they keep flying that flag. and people from around the world are heavily engaged in Singapore. So knowing it exists is important, because the whole point of that is to say it's continuing the conversation with about mediation in its widest sense. I don't. Is there anything particularly rocket science for me to say? Well, look. I think you need to. This is worthwhile remembering. It's very short. I don't think there's anything there that's particularly difficult or controversial to accept. So there's nothing I would say. I think the proof of the pudding, just looking more holistically, is the eating, of course, and seeing parties sign up and continuing to promote it. But I would use it just as a kind of a lever as much as anything else, as part of just promoting. When you're talking about mediation, selling it, not taking it for granted that parties know this. So you can say, all the benefits of mediation, and to the extent they may subconsciously be thinking about it, flagging and bringing to their attention. And of course, there is this convention to assist in situations for enforcement. I think all of that has to be a positive thing. So it's difficult, I think. I'm conscious it sounds like I'm evading the question, but I think the key thing really is to know it's there and to factor it in as part of your conversation with your prospective users of mediation.
Thanks, Joe. That was really educative. There's one question we say, if you have to gaze the mediation crystal ball, what is the impact of the convention you see after a few years?
Well, look, that's an interesting question. Of course, anybody predicting anything these days is very dangerous because the world changed. But I think we're already seeing that. There's a very interesting initiative that I thought slipped under the radar, certainly in my part of the world, in the Western Hemisphere. But China is taking the lead very much on this, the International Convention on Mediation. And they've kind of taken the lead, having taken Singapore's lead, if you like, with the Singapore Convention. They have now ratified, there was 33 countries, I think, that ratified back at the end of May, a convention to promote, it's the first intergovernmental purely mediation dispute resolution service. So it's supposed to be like a permanent court of arbitration that you see in The Hague, but for mediation. And it's an interesting mix of, it's a little difficult looking at their website. It's still hard to know who's actually signed up to it. It's very nascent and it's not actually up and running yet, but their headquarters is in those in Hong Kong will know the old police station on the harbour front there. It's a very distinctive building. So it's a serious maneuver on behalf by the Chinese primarily who have pushed this forward. And I think that's an initiative one to watch. But I think that has come very much on the back of the Singapore Convention. So, I mean, there's a limit to what you can do with the convention other than get more people to sign up to it. And then think of another convention perhaps that nobody has just yet. But I think it's that knock-on effect with other institutions promoting mediation going forward, and that's not just investor-state that's not just state-to-state mediation, which is its primary goal, but it will look at investor-state mediation and indeed even private mediation. So that's an interesting initiative that is literally kind of evolving as we speak. So this is why I go back to saying, we're in a really interesting time at the moment. So it will be interesting to see. I look forward to a discussion, whether it's next year's seminar program or in the next couple of years, to see, as I say, there's often a lot of noise. It's then interesting to see what actually comes to fruition. And I'm really hopeful that in India, in particular, because I can't let you off the hook as I'm on the line with you now, that we do see a greater acceptance of mediation. I see great things, I hear great things, but it would be nice to see a true. The trouble is with all of these things, it involves a cultural shift, and changing cultural mindset takes a long time.
Yeah, thank you, Joe, for that answer. You were saying that we are really in interesting times, and there's an interesting questions about AI and and mediation. I have just lost the question because too many. So the questions is from Mr. Ashutosh Sharma. He says, how do you see AI as a potential mediator compared to human mediator, who may sometimes be biased? While AI is not inherently unbiased, but it's possible to create AI models that are truly impartial and unbiased.
Well, I'm not sure if it is technically possible to do that for the very reasons whoever's designing the algorithms have their own inherent biases. But look, I think my general reaction to AI is I'm not in panic mode yet. I think it is a very useful tool to help perhaps in preparation, but I think it's no more than a tool. And I think I can't personally, at the risk of being, well, A, sounding defensive and maybe completely in denial, I can't see it replacing proper mediation. In fact, I would even query if you don't have a human involved, whether that you could call that mediation. Maybe you'd have to call it something else. But I leave that floating in the air because I think there's so much about mediation that is so personal, that is discretionary, that is that skill of the mediator, him or her that's there, that can read the body language, that can see things that it's almost impossible, I think, to predict. There's so much that comes out that you reading from the papers, the pretty dull black and white, he said this, she said that scenario, to when you in the heat of the moment and when you win trust and you start being told information that you really find out this is what really matters to somebody, whether it's an apology or something else that actually doesn't seem at all obvious. So I'm not going to say it's not going to happen because obviously AI is developing at such a fast rate. It's one to watch. I think all of us would be foolish to ignore it, but I think I would. I'm actually looking forward, and I say this sincerely, to exploring it more so I can adapt it more into my practice and make my life a little easier, to make hopefully me a bit more efficient. But I can't. I'd like to think it wouldn't replace me, and that somebody would rather speak to a machine than me. But that's my view.
Thank you, Joe. I think this would be the second last question. It says, what step would you recommend for enhancing the current mediation process, and which specific area should be prioritized for further research and development? Again, the name is missing, so I can't.
That's a great question. Look, I mean, again, I think it comes back. Again, I'm going to go slightly controversial, but as we're amongst friends, I'm sure nobody's going to quote me. I think we need to be more assertive about the benefits of mediation, certainly in the commercial space. And I think we need to be recognized, as I mentioned before, as a broad church, and that, great family mediators are great. They have particular skills. But equally, I think we are too defensive in order to try and promote and encourage people to use mediation, to sell it a little bit on the soft side. Is my personal view. And I think this is a universal issue. I think we have to be a bit more assertive, less defensive, and truly saying what the benefits are. Because when you hear them, I challenge anybody to say, well, it's no-brainer, really. It's not rocket science. And yet you keep, everybody seems to agree, and yet it is such a challenge to sell it, particularly in the commercial context, which seems to be kind of contradiction in terms, that inevitably it's human beings behind it. Number one is ignorance. Knowing about it is super important. And the lawyers have an important role to educate themselves and their clients. And of course, when people don't know things, they're suspicious. They're naturally suspicious, but they can be overcome, and experience can placate that, I think, natural suspicion and perhaps fear. Even, but I would be much more assertive. And I think there is I think it's a perception that mediation is really for kind of, well, it's more family, touchy-feely kind of scenarios, employment where you've got to tread a little carefully. But for a really serious commercial dispute where there's a lot of money, it's got to be litigation or arbitration. And I would push back very strongly on that, because I think there's always a limit whether it's litigation or arbitration, because there's a claim, and there's a defense of that claim, and that's pretty much what you're going to get out of any process. Whereas with mediation, when you look at, you're able to change the focus from rights to interests, the ability to create truly constructive, helpful settlement agreements, that come from the parties, so that deals with enforcement, but that help them get on and do their business together. Is something that I think is we're a little bit too shy in putting that forward. And so the trouble is, it's a difficult message. And as I say, if you oversell it, you can sound a little bit too evangelical. And I think to clients who can be a little bit schizophrenic, again, with all due respect to them, because if you start suggesting alternatives, they query whether your commitment to the case, whether you're really the tough lawyer. And I always say, for me, the good mediator, or as a practitioner, is the one who can spot an opportunity for resolution. The great mediators, practitioners, are the ones who can create those opportunities from a position of strength. So ultimately, you're representing your client. You want the best deal for your client. This is all about the client's best interests. So again, sorry, a little bit long-winded answer, but I think going forward, we've been carrying the flag for a long time. There are more of us carrying that flag. The more, the better. And there's a real, as I say, in somewhere like India now, where I'm seeing all this wonderful movement and opportunity. I just would like to see that actually coming out, in a year or so time, and that actually become embedded. Because I sometimes hearing some noises that are already beginning to kind of trying to counter the more positive aspects of mediation in India. And I think this is a real wonderful window of opportunity for you.
Thanks, Joe. With your leadership, we'll carry the flag. Now, the final question, I would say, that question was from Ramya. I couldn't get the name, but now I can see the name. So the next question is from Mr. Hasit Seth. He is asking, what is your frank opinion on the mediation training industry with high price courses? Do they really bring any value or import on or impart any special skill, or it just a function of just 1 second, something is missing, function of demand supply in the market?
Yeah, well, he knows I'm not going to be afraid to give my frank assessment. I won't name names. One thing I would say, there are some very expensive courses, but often you get what you pay for. Some of the best ones are the most expensive ones. And one has to recognize that. But they're not all super expensive. And indeed, India has some very good courses on offer that are very run by excellent trainers. So there are alternatives out there. But I would say, in terms of the concept of training, it's fundamental. I mean, in some places it's mandatory. Some places in their law, I'm not sure what the status is in India, will say you have to have been trained and accredited by some. So it's arguably unavoidable, but it's also fundamental. And I think in terms, while I was talking about the importance of on-the-job training, you do need to come with it with some understanding and training, and courses, whether expensive ones or less expensive ones, but they have to be good ones, really are very helpful for equipping you. Because I think while anybody, again, in my jurisdiction, we don't need a special requirement to be a mediator. Anybody could be a mediator. It's not regulated. But there are people that will come to it with certain ideas, their own baggage, and it's a different mindset. It's particularly if you're a litigator, dare I say, it's even harder for us, because we come to it with our own kind of baggage. And so I think formal education and training by a recognized, reputable organization, hopefully cost-effective one, is definitely worth doing.
Thanks, Joe. I think one final question, if you can give a short answer, is from Thiagarajan. It says whether Med model will work in international commercial disputes.
Ooh, great question.
Yeah.
There was again, this goes to, in international, theoretically, yes. And of course, one can never say never. It just doesn't happen in practice, in reality. Certainly not in my part of the world. I think more perhaps in China, certainly. One thing, some jurisdictions, Switzerland, Germany, are a bit more open to it. But there's a real issue. I think one is, it's not impossible to see, certainly having separate arbitrators, mediators, that's to work in parallel. Definitely possible, but having the same person is problematic, certainly for most common law jurisdictions, but I would also say a lot of civil law jurisdictions in the West. I think that concept of combining the two is problematic for us. But yeah, there is scope for that, and but I certainly think there can be a lot more use of mediation with arbitration, for example, but for some bizarre reason, it's not used as much as in, say, litigation and mediation, and certainly in my jurisdiction. And where it is used in arbitration, it's not a high success rate as in litigation. So there's definitely room for improvement of using these processes together.
Thank you very much, Joe, for all those answers. I think everybody has got their answer. Now, as we bring this session to a close, let's briefly reflect on the key points from today, from Joe's lecture. As Joe said, the Singapore Convention fills a long-standing gap by creating a uniform enforceable framework for international mediated settlement agreement. Its scope, reservations, and enforcement mechanism make it both powerful tool and one that requires precise drafting and process management. Looking ahead, its success will depend upon adoption by most states, familiarity amongst practitioners, and integration into dispute resolution planning from the outset. On behalf of Nivaran, I extend out sincere thanks to Mr. Joe Tirado for sharing his deep expertise, and to all participants for your active engagement over the past 11 days. Tomorrow, we meet for the closing ceremony, and it is open to all. Please do invite your family, friends, and colleagues to join us. Ms. Prabha Swami would be hosting the closing ceremony tomorrow, and Ms. Abha Sharma would be rendering the closing remarks tomorrow. A very special thanks for our excellent technical team, Mr. Rahul, Mr. Rohit, and Mr. Keshav, for keeping each session seamless. As the Chief Justice of India in the opening ceremony reminded us that starting and ending time it has to be on time, and it is actually a mark of respect for everyone involved. I'm glad that we are nearly, upheld that again today. So thank you all, and I look forward to seeing you at the closing ceremony tomorrow. Thank you. Thank you very much.
Thank you for hosting us,
you.
Devraj.
Thank you, Joe. Thanks.
Thank you, Joe.
Thank you.